All right, are you Deborah K. Hatfield appearing there from the jail?
Yes.
It's case number 24 CR 74, State of Ohio versus Deborah Hatfield. This is a hearing being conducted by Zoom to review the bond set in her case. She was arraigned on Tuesday, I think, yesterday. Maybe it was Monday. Yeah, it was Monday. Bail was set in the absence of counsel. Her attorney is William Armentrout. He's actually present here in the courtroom, and also present representing the state is in the courtroom is prosecuting attorney Collins. Defendant was indicted on 3 counts of aggravated trafficking, 3 counts of aggravated possession of methamphetamine. And bond was set in the amount of $20,000. All right, Mr. Armentrout.
No, I've not had a chance to speak to my client yet, so I'm not aware of any priors that she may have or any prior failures to appear. In light of the most serious charge of F3s, I think we'd ask the court to consider no bail bond in the matter. If that's not appropriate and other information becomes relevant, I'll apply to the court.
All right, Mrs. Collins, on behalf of the state.
Thank you, Your Honor. We would note the level of offense in these cases, as well as the fact that the defendant has had a warrant since May in this case. We were only recently able to locate her.
Now, I'm looking at the Ohio Court Network here. I don't see any convictions, but I do see some arrests reported back in 16 in Pike County. And state aware of any record of this defendant?
No, we were not able to
Okay.
find a record either.
All right, well, and what's your address, Miss Hatfield, that you're living at, or were living at when you were arrested?
2900 Stony Road, Peebles.
All right. Yeah, because originally it was reported as Hackerson. All right. Well, I'm going to order the bond be reduced to $10,000 plus the conditions in your original arraignment entry. Given the fact that it took so long to find you and you'd moved, you're living out of county. And again, as Mr. Armentrout said, I don't know if you heard him or not, but if he comes up with any further information, and the court will certainly consider any future modification. All right? Thank you.
Thank you.
Okay. All right, this is State versus Tommy LaRose Showman. Is that how you pronounce that, Tommy?
Yes.
All right. Tommy LaRose Showman. Showman, you were indicted by the grand jury of this county on September the 10th on 2 counts of telecommunications fraud. The charge alleges in count 1 that on or about July 27, 2024 in this county, that you did knowingly make the cause to be made a telecommunication to another, and the caller knowingly made the telecommunication to the recipient of the telecommunications or to another person at the premises, and you the person previously told you not to make those telecommunications or those premises. You've been previously convicted of a violation of this same section, and that'd be a violation of 2917.21 85 revised code. And the second count alleges that you violated a different section of the same statute on the same date and time by causing to be made, permitting to be made a telecommunication from a device under your control with the purpose to abuse, threaten, harass, or another person. And you had the previous conviction. So those are both fifth-degree felonies, which, if convicted, could result in a term of incarceration of 6 to 12 months and a fine of $2,500. Now, you're entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one for you. See, you're on SSI according to your financial disclosure form, and that you're receiving $700 a month. Is that correct?
Yes, Your Honor.
All right. All right, the court then will find that you are entitled to appointed counsel. Court will appoint Attorney Catherine Hapner to represent you. In the absence of counsel, enter a non-guilty plea on your behalf. We'll set a pretrial for you for October the 16th at 2:30. And
I don't know sorry, Your Honor, I don't know what day I have court with my son. I'm fighting custody for my son right now, too. So I need...
okay, well, I don't either, so that, so how does that help the...
I know, I gotta call and find out. Can I call and let you call you back and...
Okay.
Let you
You'll call your
know.
attorney back, okay?
Okay.
Now, we are going to, if you have a smartphone or other device that you can do video conferencing by, we will, that can be done by Zoom. And if not,
Yeah, that's
would you
why-
quit interrupting me?
I'm sorry.
Okay, I'm doing the talking. Your job's to listen. All right? And so we would be able to do that by Zoom. So if you do have that, you give your phone number and email to the bailiff, and then we will notify you of that a couple of days prior to that. Now, your final pretrial will be set for November the 6th at 2:30 p.m. That can also be by Zoom. Your trial date will be set for December the 9th at 8 a.m. in person. Your bond is an OR only, and that's your promise to appear. That if you do not appear, then you could be prosecuted for an additional felony and convicted, sentenced on that, no matter what happens in this case. They'll be required to pay a service fee deposit of $171 to the clerk for certain statutorily required fees. That'll be due within 30 days. Make payment arrangements with the clerk to do that. You'll be under pretrial supervision of the probation department at 117 East Main Street, and that is located just down the street from here, across from the flagway station on the other side of the street. You'll be required to report to them immediately after court. You'll be required to report once a week for 4 weeks. After that, as they determine, undergo random drug testing. They may order. Provide phone numbers for home, cell, and employee if you become employed. Have no contact with the alleged victims. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatments indicated, you enroll in and follow that during the pendency of this action. And you'll also be under house arrest at your residence. And is that in Chillicothe right now?
Yes, Your Honor.
All right, you'll be required to be there at all times unless you're working or going to and from work, or any kind of medical appointments, court proceedings in this or any other case, appointments with a probation officer, or attorney in this or any other case. You can also attend any kind of schooling, job training, et cetera. And church services. And if you fail to comply with these conditions, then you could have your bond revoked and be held till further order of the court. Now, did you go out to the, were you photographed and fingerprinted out at the sheriff's office when you were served?
I don't think so.
All right, where were you served with your indictment?
I was served at my mom's house.
Okay, then you'll need to go out to the sheriff's office. So you're going to make 3 stops here this morning. You're going to sign an assignment notice, gives you your date and times of your hearings with the bailiff. You're going to go down to the clerk's office to sign your OR bond, and then you're going to go to the probation office to report for pretrial supervision, and then you report to the sheriff for booking, and they'll just do the fingerprinting, photographing, and so forth. Now, the other thing is, I'll also make a comment, is that I think it was last week or the week before, there were several emails sent to the court's email address from you. I purged those and put a block on it because it's improper for you to communicate with the court without copying the opposing counsel, and you are now represented by counsel, so you should not be communicating directly with the court. You communicate through your counsel. You get her phone number from the clerk's office. All right. You have any questions? All right. Then you come over here. Thank you.
Chairman, I have approached Mr. Strino, would I
We haven't received the PSI summary
receive
yet.
PSI, sir?
All right, go ahead. Actually, I have it. Okay.
Approach me, Chairman?
You may. Good idea, because I haven't read it either.
Thank you, sir.
Pull the rabbit track.
All right, ready?
I am, sir.
Yes, Your Honor.
All right. Now, the defendant entered a plea of guilty to failure to register a change of address as a registered sex offender. The matter was referred for the pre-sentence report, which I have now reviewed, and the parties have each been provided a summary for them to review. All right. Anything from the state?
Only was contained in the plea agreement, Your Honor.
Mr. Wagner?
Go ahead and stand up, sir. Your Honor, we would ask the court to follow the recommendation of the parties. Didn't check his jail time credit. I know he's got a significant amount of time in there, Your Honor. We would just ask the court to follow the recommendation, sir.
Okay, I don't know what that is. All right, go ahead. Mr. Williamson, is there anything you'd like to say?
You can't address the court.
You don't have to say
You don't
anything.
have
No,
to.
I'm fine, Your Honor, thank you,
A little hard of hearing, Judge.
All right.
just a little bit.
Well, the plea agreement is, the recommendation was that Mr. Williamson be granted community control. It's a third-degree felony. And as I indicated at the plea, that recommendation is not binding on the court. When I review your history, Mr. Williamson, is extremely disturbing. You have an abduction conviction from Adams County in 2009. You have a kidnapping conviction in 1993, as well as an attempted felonious assault at the same time out of Claremont County. According to that, you got 23 years in prison. Well, 15 and 8, so I don't know if they made it concurrent or consecutive. And then in 2009, you committed another violent offense of abduction. You had a 1988 conviction for weapon under disability, as well as an attempted murder charge out of Hayes County, Texas, in 1985. So that's, yeah, it's clear. I mean, your risk assessments, notes, specifically notes in a report that I have as to your violent crime convictions, as well as a sex offense that's required you to register and that you failed to comply with. And so, given your history, I think that it's a risk to the public that you be put on community control. I don't think there's much likelihood you will comply. You can't even register, it's not likely you're going to comply. So it is the order of the court that you be, and are hereby sentenced to a term of 18 months in the Correctional Reception Center in Orion, Ohio. County Sheriff, you were arrested on July 23rd. Is that correct?
July 23rd, sound about right?
What is it
When
now?
you were arrested, July 23rd?
Yes.
All right. So you'll be given 67, well, actually, this is a little out of date. It's printed on the 27th, so that'd be another 5 days. So it'd be 72 days of jail time credit. Now, upon completion of this sentence, Mr. Williamson, the Adult Parole Authority may put you under post-release control for a period of up to 2 years. If they do, you'll be supervised under terms that they set. And if during that period of time they determine that you have not complied, they can return you to prison to make you serve an additional period of up to 1 year, or I'm sorry, up to 9 months for one violation, up to a maximum of half of your prison term, or which is also 9 months for all violations. But if you commit a new felony, then in addition, whatever sentence a judge in that new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence of the new case. You're also ordered to pay the court cost, and if you fail to do that, the court could, or the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, once you get out, the court could permit you to do community service in this county and give you credit for each hour you work, and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded back to custody. All right, this is 23 CR 125, State of Ohio versus Gary Lee Pettiford. Appearing on behalf of the state is Prosecuting Attorney Collins and Assistant Prosecuting Attorney King. Appearing on behalf of the defendants, Attorney Jacob Wagner. You're Gary Lee Pettiford?
Yes, sir.
All right, Mr. Pettiford was convicted after a trial by jury on 2 counts of rape and was sentenced back on August the 21st of 2023 to the mandatory term, which was on each count of 10 years to life. That court ordered those to be served consecutively for a total of 20 years to life. The defendant did file an appeal. Appeal was affirmed except for finding by the court that in their view, not mine, but in their view, which is the one that matters, I had not made sufficient findings on the record to sustain the consecutive sentences. And so the matter was referred or remanded back to the court to conduct a resentencing only on the purpose of determining whether the sentences will be consecutive or concurrent, because the sentences are mandatory, and so there's no question about the sentence, the validity of the sentence itself, but only the issue of whether they should be consecutive. Counsel agree with that, Mr. Wagner? That's the sole issue.
Yes, sir. Yes, Mr. Pettiford, I'm sorry, sir. Stand up. Mr. Pettiford and I spoke this morning. We both agreed that was the issue before the court today. We're not arguing guilt or innocence, just the appellate issue and sentencing.
All right. Now, Ms. Collins, had the victim of the offense or the representative been notified of the time, place, and purpose of this hearing, the right to be present, to be heard?
They have, Your Honor, and will not be attending.
All right. Anything from the state then regarding sentencing?
We would ask the court again to impose the sentence that was previously imposed following the jury trial. We would note that the serious nature of this offense and the defendant's conduct would require consecutive sentences in order to protect the public from future harm. That the 2 offenses that he was convicted of were separate offenses with 2 different courses of conduct, if the court recalls from the trial. And based on that, we would ask the court to impose consecutive sentences of 10 years, life with the possibility of parole after 10 years.
Mr. Wagner?
Yes, sir, Your Honor. I don't want to say a disadvantage, but kind of at a disadvantage. I wasn't the trial attorney at that phase, Your Honor, but I do understand the proceedings before us. From my understanding, Your Honor, the court's hands are semi-tied as far as the mandatory minimum sentencing the court must impose. There's no procedural issue here today. That being said, Your Honor, we just stand before the court to submit to sentencing, Your Honor.
All right. Mr. Pettiford, is there anything that you would like to say? I know you've had some difficulty standing, so you can remain seated.
No, I'm not just fully aware of what's going on here this morning.
You are or are not?
Not clearly, no.
Well, the issue, the court, what happened with the appeal, your appeal was affirmed, finding your convictions were appropriate, and the sentence of 10 years to life is appropriate because it's the only sentence. I ordered you to be sentenced to serve those consecutively, meaning one after the other, so that means it would be 20 years to life. Court of Appeals said that there was not enough information that I put on the record to sustain that, and so they sent it back to the court for me to redo that in terms of deciding whether or not you should get consecutive or concurrent sentences. So that's why we're here. Okay? All right, so with that understanding, do you have anything that you would like to say before I pronounce the sentence?
No, Your Honor.
All right. Well then, as the court has indicated, the sentences that must be imposed in this case as a mandatory sentence of each count is 10 years to life. And so the court does, again, sentence the defendant in accordance with the statute and pursuant to the findings of the court that the convictions were valid to a term of 10 years as a minimum, up to life as a maximum, with the eligibility for parole after 10 years. Now, the court finds that in its view, the consecutive sentences are necessary to both protect the public and other young women from future crime by this offender. Further, is for the purpose of punishing this offender because there were two separate courses of conduct which were very egregious, and he was just almost caught in the act, as the court recalls from the evidence, when the officer came to his house. And the court finds that consecutive sentences, in this case, they're not disproportionate to the seriousness of the conduct because the statute itself recognizes the seriousness of the offense by imposing this as a mandatory sentence. And the court's view that the type of conduct was so egregious that it clearly poses a danger to the public and particularly to young women in the future. The court also finds that the harm caused by these separate offenses, although against the same victim, were so great or unusual that no single prison term for the offenses committed as part of the course of conduct would adequately reflect the seriousness of the offender's conduct. Again, the offenses were committed as one course of conduct, but two clearly separate offenses, and therefore is necessary. The defendant does have a previous history, although not of some time ago, so the court doesn't find that's a major contributing factor, but the other two factors that I've cited, the court feels, based upon the evidence in this case, that those two findings under the statute are sustained, and therefore it is appropriate that the sentences be served consecutively. And so that will be the sentence of the court. All right. Is there anything further from counsel?
What do I put for jail time credit?
No, we don't do that because he's already there.
Okay.
So this is just a, well, whatever the original jail time credit was is what would be for this case. And then plus all time that he served since the imposition of the original sentence was in August of 23. I think that's the way I'll word it. So, all right. So we'll do an amended or a new judgment entry of confinement, and put in there the time of the original sentence plus all time since that date. That way he'll get credit for whatever time he was in jail and in all the time he's been in prison. All right, anything further, counsel?
No, sir.
All right, you're remanded back to custody, Mr. Pettiford. Thank you.
Sure.
All right, this is a State of Ohio versus Harry Smith. There are several cases, 01CR125, 01CR148, 01CR182, 02CR001, 023034063, and 110, and 09CR83. Matters before the court today on the defendant's motion filed in July of this year to vacate, I believe July 9, to vacate all court costs and any other prosecution fees. The matter was originally set for hearing on August 28th, and then the defendant filed a motion to continue on August 21st, requesting additional time to prepare for the hearing. The matter was then continued to October the 2nd, today at 10 a.m., with defendant agreeing to that by phone call with the assignment commissioner. It's now 10:32. The defendant, actually 10:28, I guess. The clock's fast, but the computer says 10:28 a.m. The defendant did not appear. The assignment commissioner attempted to reach him by phone and was able to leave a message, I believe, but there's been no return call. He has not appeared, and therefore the motion is denied. All right. Case number 24CR116, State of Ohio versus Justin Alexander Brooks. Mr. Brooks is appearing by video from the Justice Center. Mr. Brooks, you were indicted by the grand jury yesterday on 3 charges plus a forfeiture specification. The first count is aggravated trafficking of methamphetamine under 2925-0382. It alleges that offense occurred on or about August the 2nd of this year in this county, at which time it's alleged that you knowingly prepared for shipment, shipped, transport, delivered, or prepared for distribution, distributed methamphetamine in amount over bulk, and you knew or had reasonable cause to believe it was intended for sale or resale by yourself or another. Count 2 is aggravated possession of methamphetamine, alleges at the same time and place you possessed that amount of methamphetamine. And then count 3 alleges on or about August 2, 2024 in Highland County, Ohio, that knowing that an official investigation was in progress and likely to be or about to be instituted, you altered, destroyed, concealed, or removed documents or things with purpose to compare their value or availability. That would be tampering with evidence if proven under 2921.12A1. All of those are third-degree felonies. Each of those carry a possible prison term if convicted of between 9 and 36 months, and a fine of $10,000. Counts 1 and 2 carry, count 1 carries a mandatory fine of $5,000. Now, you are entitled to have an attorney to represent you in this matter. And if you don't have the money to hire one, the court will appoint one for you. Again. There it is. All right, I see you've completed that form. And in case you're unemployed, you have no income, is that correct?
I want to hire one, actually.
I'm sorry?
I've got an attorney, a lawyer, Jim Chandler.
Okay, who's hiring him?
My family.
All right, and has he agreed to be your attorney, or do you know?
Yes, sir, he has.
All right, does he know about your indictment?
I'm pretty sure.
All right, well, he's not entered an appearance, so what I'm going to do, I'll make a note here that Mr. Chandler is employed. Mr. Chandler, and we'll contact him to see if that's the case. In the absence of counsel, then I'll enter a not guilty plea on your behalf. I'm going to have a bond review hearing on this case tomorrow, October the 3rd at 8:30 a.m. by Zoom. We'll notify Mr. Chandler so that he can appear, and if not, then that'll be continued until you do have counsel. Are you being held on this charge only, or do you have other charges that you're being held on?
Yes, I was being held on other charges, but yesterday I signed papers to go to treatment.
Well, my question was, are you being held in custody by another court for a
No,
criminal case,
sir.
or is this the only case you're being held on?
This is it.
This is it, all right. It says here that you're in jail, oh, maybe that's your co-defendant. You don't have an OVI that you're being held on?
Yeah, but I signed a paperwork yesterday to go to treatment for that.
Oh, okay, so you're in jail on the OVI right now.
PV, yes.
Yeah, because according to this, you were granted an OR bond on August 7th.
Yes, sir.
Okay. All right. All right, we'll set your first pretrial then in this case for October 17th at 1:00 p.m. It'll be by Zoom, so you'll need to make sure that your attorney has your information, where you'll be and how to be contacted. Final pretrial will be set for November the 20th at 1:00 p.m. and your trial will be set for December the 9th at 8 a.m. Now, the court will grant you an OR bond only, which is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. So we won't have to have a bond review hearing tomorrow morning, so that'll be vacated, and it'll just be your pretrial schedule. Now, you have to contact the probation department upon your release. I assume they're going to be ones taking you to treatment, but you'll need to notify them immediately that you are under pretrial supervision. In this case, what that means is you'll be required to report to them once a week for 4 weeks, and after that, as they determine if you're in treatment, then they can do that by phone or Zoom, as they determine appropriate. And you're to undergo random drug testing they may order, provide phone numbers for home and cell employers to become employed, recommended by probation to be evaluated for substance abuse and mental health treatment if treatment's indicated, which apparently it is. You're to roll in and successfully complete that. And do you know what treatment facility you're supposed to be going to?
The Recovery Council.
All right. So
She said,
you'll
wait.
be required to be there. You'll be required to remain in treatment during the pendency of this action. So that means if you walk away, then you're to report back to jail. If you don't, the court will issue an order for your arrest. And then at that point, you could be held until the court sets additional bond, a new bond that will ensure your appearance in compliance with your pretrial supervision. All right. So you notify your attorney then of his that your hearing is your pretrial is October the 17th at 1 o'clock. That'd be 2 weeks from tomorrow. All right.
Okay.
Do you have any questions?
No, sir.
All right. Thank you.
Thank you. Have a good day.
All right, this is case number 24 CR 133, State of Ohio versus Preston Kress. You were indicted by the grand jury yesterday, Mr. Kress, for trafficking in a fentanyl-related compound, possession of fentanyl-related compound, trafficking and possession of cocaine, and a forfeiture specification. The criminal charges, count one, is that on or about July 8, 2024, you knowingly prepared for shipment, ship, transport, delivered, or prepared for distribution of fentanyl-related compound that was over 200 unit doses, less than 500 unit doses, or over 20 grams, less than 50 grams, knowing it was intended for sale or resale by yourself or another. And then count two alleges you possess that same amount. Each of those offenses are first-degree felonies which carry a mandatory prison term of at least 3 years and up to 11 years as ordered by the judge. And as a minimum, the maximum being an additional 1/2 being added to that by DRC if they determine that's appropriate. There's a fine of $20,000, a mandatory fine of $10,000, and possible license suspension of 6 months to 5 years on each count. Count three alleges that on or about July 8, 2024 in this county, the same charge, except it's alleged it was cocaine and that the amount was 10 grams but less than 20 grams, otherwise the same thing. And that also alleges you've had a previous, 2 or more previous felony drug abuse offenses, and that would therefore make that a 3rd-degree felony. And then count four, the possession is the same offense, and that is alleged to be a 3rd-degree felony. Those carry possible prison term between 9 and 36 months, fine of $10,000, mandatory fine on count three of $5,000, and a license suspension of 6 months to 5 years. And then the state alleges in count 5 that you possessed $22,305 in U.S. currency subject to forfeiture due to facilitation commission of these offenses. All right. Now you're entitled to have an attorney to represent you, and if you can't afford to hire one, the court will appoint one for you. And I see that you filled out a financial disclosure form. Is everything on this form correct?
Yes.
All right. And have you been in court on this charge before today?
No, Your Honor.
All right. The court will appoint attorney William Armentrout to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf.
Okay.
Bond will be set in your case in the amount of $50,000. We'll have a bond review hearing on your case tomorrow morning at 8:30 by Zoom. Your first pretrial will be October the 16th at 1:00 p.m. Final pretrial will be November the 9th, or I'm sorry, not November the 9th, November the 6th. And we'll set a trial date of November the 14th. 1 o'clock on both pre-trials, yes. And then the trial will be at 8 a.m. on November the 14th. Now, in addition to the $50,000 bond, you're also required to assign an OR, which is your promise to appear. And if you don't appear, you could be charged with an additional felony, and if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay a deposit to cover certain statutory required fees of $171 prior to release. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You'll be required to report to them as soon as you're released, and then report once a week for 4 weeks, and after that, as they determine, undergo a random drug test they may order, provide phone numbers for home cell employer, recommended by probation to be evaluated for substance abuse or mental health issues. If any treatments indicated, you enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence at 11882 Carytown Road, Leesburg, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. Otherwise, you must be there at all times. If you fail to comply, then that bond could be revoked. You could be taken into custody until further order of the court. All right, you have any questions, Mr. Kress?
No, Your Honor.
All right, thank you. All right, are you Chase Aaron Ray Huntsman?
Yes, Your Honor.
All right. This is case number 24 Sierra 134, State of Ohio versus Chase Aaron Ray Huntsman. Mr. Huntsman, you were indicted by the grand jury yesterday on charge of aggravated trafficking in drugs, alleging on about February 21, 2024, you had knowingly sold or offered to sell oxycodone. And count 2 alleges on about the same date that you possessed that amount. Count 1 is a 4th-degree felony, which carries a possible prison term between 6 and 18 months, fine of $5,000. Count 2 is a 5th-degree felony, carries a possible term of 6 to 12 months and a fine of $5,000. Now, you're entitled to have an attorney to represent you in this matter, and if you can't afford one, the court will appoint one for you. So you have filled out a financial disclosure form. Is everything on this correct?
Yes, sir.
When's the last time you were employed, Mr. Huntsman?
It would have been about 3 or 4 months ago at Walmart here in town.
All right.
I just got my license redid probably 2 weeks ago.
All right. Court will appoint Attorney Sarah Barger of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. And I'm looking through a court report, network report. You don't have any previous felony convictions?
No, Your Honor.
All right.
I am in treatment right now,
Where's that?
outpatient. It's with my MD. It's on my phone. Like I said,
Okay.
it's an outpatient. Yeah, it's an outpatient thing, but I also have probation.
Okay.
So, right.
All right, well, I'm
But I
going
have-
to set your bond as an OR only, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay a deposit of $171 within 30 days to cover the statutorily required fees. You must report to probation department at 117 East Main Street as soon as you get out of jail. You know where that's located, across from Flagway, up here in Hillsborough.
I can find it.
All right, it's right uptown in just a half a block east of the main intersection on the south side of the street, across from the Flagway and the bakery. You'll report to them immediately after release. Report to them once a week for 4 weeks after that as they determine, undergo random drug testing. Provide phone numbers for home, cell, employer, and if recommended by probation, you'll be evaluated for substance abuse and mental health issues, make treatments indicated. You enroll in and follow that during the pendency of this action, and treatment by phone is not included in that. You'll have to do it in person. You'll also be under house arrest at your residence at 338 North 2nd Street in Greenfield, meaning you have to be there unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of educational programming, job training, etc. Also, you can attend church services. Other than that, you have to be there at all times. If you fail to comply with these conditions, then your bond could be revoked. You could be taken into custody and held till further order of the court. We will set your first pre-trial in this case for November the 6th at 2:00 p.m. That can be by Zoom, but you'll have to coordinate with the probation department and your attorney and provide the information that's necessary for that invitation to get to you and have the device for that. If not, you can do it from the probation department. Final pretrial will be November the 20th at 2:00, and your trial date will be set for December the 19th at 8 a.m. All right, we'll notify your attorney of her appointment. You can also get her phone number from the sheriff there or at the probation department. Make sure you reach out and make contact with her immediately.
Okay.
Do you have any questions?
No, Your Honor. Thank you.
Thank you. All right, are you Kevin Stewart?
Yes, Your Honor.
All right, Mr. Stewart, you were indicted by the grand jury yesterday, looks like on 6 counts, 3 counts of trafficking, 3 counts of possession of a fentanyl-related compound. Each of those alleges that on or about, in count 1, January 26, 2024, you knowingly sold or offered to sell a fentanyl-related compound over bulk less than, over 1 gram, less than 5 grams. Count 2 alleges you possessed that amount. Count 3 alleges, on the same day, count 3 alleges that you trafficked on February 22nd in the same amount. And count 4 alleges you possessed on February 22nd that same amount. And in count 5 alleges there was a transaction on February 23rd for the same amount. And count 6 alleges on the same date possession of that amount. Each of those are 4th-degree felonies which carry a possible prison term if convicted between 6 and 18 months and a fine of $5,000 and a possible license suspension of 6 months to 5 years. Now, you're entitled to have counsel represent you, and I believe you filled out a financial disclosure form. Everything on that form correct, Mr. Stewart?
Yes, Your Honor.
All right. And who was your attorney on your other case that you're on community control for?
Well, I don't even know his name, Your Honor.
Mr. Kirk?
Yeah, Kurt, yeah.
All right. Court appoints Dennis Kirk to represent you in the matter. And in the absence of counsel, enter a not guilty plea on your behalf. We will set a bond review for your case tomorrow morning at 8:30. And that'll be a Zoom hearing from the jail. First pretrial will be October 16th at 1:00 p.m. Final pretrial will be November the 6th at 1 p.m. And trial date will be set for December the 9th at 8 a.m. Bond will be set in the amount of $5,000 plus your own recognizance, which is your promise to appear. And if you don't appear, you could be prosecuted for an additional felony and if convicted and sentenced on that, no matter what happens in this case. Required to pay a service fee deposit of $171 prior to release. If you make bond, you'll report to the probation department immediately at 117 East Main Street. Report to them once a week for 4 weeks. And after that, as they determine, undergo random drug testing, may order, provide phone numbers for home, cell, employer. Recommended by probation, you'll be evaluated for substance abuse and mental health issues, and any treatments indicated, you enroll in and follow that during the pendency of this action. And you'll be under house arrest at your residence, meaning you have to be there all times, unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointment with a probation officer or attorney in any other, this or any other case, attend any kind of job, or educational programming, job training, college, GED, etc. You can also attend church services, other than that you have to be there at all times. If you fail to comply, then you could be placed back in custody and have your bond revoked until further order of the court. All right. Do you have any questions, Mr. Stewart?
No, sir, Your Honor.
Thank you.
Yeah, my bond is up.
right, are you Joey Fender appearing there from the jail?
Yes, sir.
All right, case number 24 CR 140, State of Ohio versus Joey Fender. Ms. Fender, you were indicted by the grand jury yesterday on 6 counts, 4 individually and 2 with a co-defendant, Christopher Burns. Count 1's alleged that on or about June 11, 2024, you knowingly sold or offered to sell methamphetamine over bulk, less than 5 times bulk. Count 2 alleges on that same date you possessed that amount. Count 3 alleges that you, on June 19, 2024, knowingly sold or offered to sell methamphetamine over bulk, and count 4 alleges you possessed it on that date, the same amount. Count 5 alleges on or about June 29, 2024, that you and a Christopher Burns knowingly sold or offered to sell methamphetamine over bulk. And count 6 alleges on the same date that you, 2 of you knowingly possessed that amount. Each of those are third-degree felonies. Each third-degree felony carries a possible prison term between 9 and 36 months and a fine of $10,000 and a jail or a license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you, and if you do not have the money to hire an attorney, the court will appoint one for you. I see you have filled out a financial statement as are you on SSI, or are you just on Medicaid?
I just get Medicaid and
All
SNAP.
right. Okay. And are you employed then?
No.
Do you have any other income?
$500 from a trust.
$500 from a trust?
Yes,
All right.
that's per month.
All right. Have you been in court in this case before today?
No.
Well, actually, you had
In
a
what?
preliminary hearing. It looks like Mr. Wagner represented you. All right.
Oh,
So the court will appoint Jacob Wagner to represent you. Are you being held in custody on any other cases right now?
no.
And when were you arrested?
Last night, yesterday.
All right. Court will appoint Jacob Wagner to represent you in the absence of counsel or enter a not guilty plea on your behalf. We'll set a bail review hearing for you tomorrow morning at 8:30 by Zoom. First pretrial will be October the 17th at 1 p.m. And that can be by Zoom. Final pretrial will be, wait a minute, I need to do a calculation here. All right, final pretrial will be November the 20th, 1 p.m. And your final, or your trial date will be December 19th at 8 a.m. Bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony. And if convicted and sentenced on that, no matter what happens in this case, you'll be required to pay a deposit of $171 prior to release to cover certain statutory required fees. Be under pretrial supervision of the Probation Department, 117 East Main Street. The Hillsborough. So if you make bond, you'll report to them immediately upon your release. And then once a week for 4 weeks, and after that, as they determine, undergo random drug testing, may order, provide phone numbers for home cell employer, recommended by probation. You'll be evaluated for substance abuse and mental health issues. If any treatment's indicated, you enroll in and follow that during the pendency of this action. And you'll also be under house arrest at your residence, meaning you have to be there at all times, unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can also see an attorney or probation officer in this or any other case. You can attend any kind of educational programming, classes, etc., and church services. Other than that, you have to be there at all times. Failure to comply could result in the court revoking that bond and having you held till further order of the court. I will notify your attorney of his appointment. Do you have any questions?
Yes.
All right, thank you. Deputy, if you would also inform Ms. Bender there's a no contact order with her co-defendant, Mr. Burns.
I will do that, sir.
Thank you. All right, are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got on this paper charged with all cap letters.
Are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got charged on this paper with all capital letters.
All right, I can't understand what he's saying, Deputy Malone. Can you repeat it?
I am the living man, Christopher Burns, not the entity you got charged with all cap letters on this paper.
Okay. Well, obviously you're living or you wouldn't be there. Just answer the question if you are, and you are Mr. Burns. So, Mr. Burns, you were indicted by the grand jury yesterday on a number of charges. First 4 counts, I'm sorry, just on 2 counts, I'm sorry. The fifth and 6th counts. And count 5 alleges that on or about June the 29th, 2024 in this county, you knowingly sold or offered to sell methamphetamine, a Schedule II controlled substance, in amount over bulk, less than 5 times bulk. And then count 6 alleges that on or about the same date, you possessed that amount. Now, each of those are third-degree felonies which, if convicted, carry a possible prison term between 9 and 36 months and a fine of $10,000 and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one for you. And I see you filled out a financial statement. Is everything on this financial statement correct?
Yeah.
All right. When's the last time you're employed, Mr. Burns?
I don't know. I like to see the official criminal complaint against me, and I like to plead the fifth. I ain't got nothing else to say.
All right. Court will find that you are entitled to appointed counsel. I'll appoint Attorney Dennis Kirk to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf.
I don't want to enter no plea. I like to see the official criminal complaint against me first.
Well, you're going to need to talk to an attorney first. I'm not in a position to do anything today until I hear from everybody involved in the case on both sides. So In your absence, counsel, the court enters a not guilty plea on your behalf. I'll set a bond.
I don't want it.
Don't interrupt me, Mr. Burns. I'm going to set a bail review hearing by Zoom tomorrow at 8:30. There'll be a final, a first pretrial on your case on October the 17th at 1:00 p.m. There'll be a final pretrial on November the 20th at 1:00 p.m. And then the trial will be set for December the 19th at 8 a.m. Bond will be set in your case for at $5,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay service fee deposit of $171 prior to release to cover the statutorily required fees. If you make bond, you'll be on a pretrial supervision of probation department at 117 East Main Street. You'll be required to report to them as soon as you're released. Then once a week for 4 weeks after that, as they determine, undergo random drug testing in my order, provide phone numbers for home, son, employer, recommended by probation, you'll be evaluated for substance abuse or mental health issues. To present any treatment indicated, you enroll in and file that during the pendency of this action. You'll be under house arrest at your residence at 236 East Beach Street in Hillsborough, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any case. You can attend any kind of educational programming, classes, etc., church services, and holiday family events. And also, you're not to have any contact with your co-defendant, Joey Fender. All right, we'll notify your attorney of his appointment. We'll have your hearing. If you don't make bond, we'll have your hearing in the morning. If you make bond, there won't be a hearing. Do you have any questions, Mr. Burns?
No.
All right, thank you. All right, are you Francis Jordan appearing there from the jail?
Yes, sir.
Francis J. Jordan II?
Yes.
All right. All right, Mr. Jordan, you were indicted by the grand jury yesterday. 2 counts of trafficking of fentanyl-related compound, 2 counts of possession of fentanyl-related compound. Count 1 alleges on or about February 6, 2024, you sold or offered to sell fentanyl an amount over 1 gram, less than 5 grams. Count 2 alleges on the same date and time you possessed that. Count 3 alleges on or about February 13, 2024, you knowingly sold or offered to sell fentanyl related compound over 1 gram, less than 5 grams. Count 4 alleges on the same date you possessed that amount. Each of those are 4th-degree felonies, which if convicted carry a possible prison term between 6 and 18 months and a fine of $5,000 and a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you in this matter, and if you do not have the funds to hire one, the court will appoint one for you at no cost. And I see you filled out a financial disclosure form. Get it here. All right, it says you're on SSI, is that correct?
Yes, sir.
All right. All right, the court then will find, oh, we have a hearing? Oh, I haven't logged it in yet. Yeah. Okay. All right, okay. I'm still finishing this. All right. I'll appoint Attorney Danielle Witt of Hillsborough, Ohio to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bond review hearing for you tomorrow morning at 8:30 by Zoom. There'll be a first pretrial on October the 17th at 1 o'clock p.m. Final pretrial will be November the 12th at 1 o'clock. And the trial will be set for December the 19th at 8 a.m. Bond will be set in the amount of $5,000 plus your own recognizance, which is your promise to appear. Fail to appear, that you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, be required to report to the probation department once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, employer. If recommended by probation, be evaluated for substance abuse or mental health issues and treatments indicated. Enroll in and follow that during the pendency of this action. You'll be under house arrest at your residence at 529 McKell Avenue in Greenfield, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job, training, schooling, educational programming, church services, and if you make bond, any family holiday events. Other than that, you have to be there at all times, and if you fail to comply, then the court could revoke this bond. You can be held till further order of the court. All right, do you have any questions, Mr. Jordan?
I have cancer, been diagnosed with brain cancer, and I got a appointment Monday the 7th, so I don't know.
All right, well, talk to your attorney about that, and we'll discuss that tomorrow's hearing. All right.
Okay.
Thank you.
All right, thanks.
All right, this is case number 24 CR 119, State of Ohio versus Brandon Scott Stewart. Are you Brandon Scott Stewart appearing there for the jail?
Yes, sir, I am.
All right, this is a pretrial being conducted by Zoom. His attorney is Jacob Wagner. He's appearing on his phone by Zoom. Appearing on behalf of the state is Assistant Prosecutor King. Defendant's been indicted in a 6-count indictment, breaking, entering, safe cracking, attempted breaking, entering, and theft. I believe this is a first pretrial, and the final pretrial is, well, I saw it a minute ago. Final pretrial is set for October 16, and trial date is set for November the 12th. All right, I see, Mr. Wagner, you received your discovery, and you anticipate any pretrial motion?
Not at this time, Your Honor. If so, it would just be a Miranda issue, but that's highly unlikely.
All right. Well, if you do have any motions, they'll be due by the final pretrial, and your compliance with discovery is also due by final pretrial.
Yes, sir.
Has there been a written plea offer received yet?
We've received it, it's been relayed, and we've gone over the discovery with my client. We counter-offered to the state, Your Honor.
All right. Is there any other matters then to bring before the court this time?
No, Your Honor.
No, sir.
All right, then we'll see you at your pretrial in a couple of weeks. All right, is Mr. Kirsch in custody?
He's in the DR room, Your Honor.
Okay.
My other client's at probation.
All right, we'll do that one then. This is a pretrial. Ms. Jordan is appearing for the probation department by Zoom, appearing on behalf of the defendant's attorney, Jacob Wagner. He's appearing by Zoom on his phone. Appearing on behalf of the state is Adam King, assistant prosecutor. Defendant charged with possession of fentanyl-related compound and tampering with evidence, third-degree felonies. This is a first pretrial. Final pretrial set for October 16. Trial date set for November 12. See, the discovery was provided, and you anticipate any pretrial motions, Mr. Wagner?
I do not, sir.
All right, well, if you do determine there are any appropriate, those we do by final pretrial along with your discovery compliance. Has there been a written plea offer provided?
And relayed, yes.
All right. All right, are there any other matters to discuss at this time then?
No, Your Honor.
All right, we'll see you at your next pretrial then, Ms. Jordan.
Yes, sir.
Thank you.
Yes, sir.
Your Honor, would you like me just to have my client come sit by me on the Zoom or come into the courtroom?
Now, come in the courtroom. Since he's in the building, we'll do it in the courtroom. She's 48. She'll be 49. All right, State of Ohio versus Robert L. Kirsch Jr., case number 24 CR 96. Present for the state's Assistant Prosecutor King. Appearing on behalf of the defendant is Jacob Wagner. Are you Robert L. Kirsch Jr.?
Yes, Your Honor.
All right. This is before the court on a final pre-trial. I believe we have a trial date set, I believe, on November the 12th, maybe.
Did it get moved October 21st, Judge, or did that get moved?
Oh, wait a minute. Well, October the 2nd was to change the pre-trial. Oh, okay, yeah. No, October 21st, yes, thank you, all right. All right, so discovery, I don't, did you comply with discovery, Mr. Wagner?
I've not, Your Honor. Can I address the court?
You may.
Your Honor, we've had some discussions with this case, and again, I just want to start by saying, one, it's a case where my client has been in my office multiple times. We've watched discovery, so he's not delaying the process. I guess what I'm asking the court, Your Honor, would the court be willing to vacate the 21st as far as a trial date, or keep it? Just to give you an update, we've got two paths we're potentially going down in this case. One, there's been a polygraph set up for the 16th of October, and my client's been offered diversion. We just got the polygraph set up within the past 24 hours, so I guess my question being, he wanted a little bit of time to think about it. Could I report to the court by Friday which route we're going to go and still maybe vacate the 21st or set it for a status?
Yeah, that would be the 5th, so that'd be all right. Friday, yeah.
I think I'm out
You're
Friday.
all right. 21st is, oh, you're out Friday?
Yeah, I can set it up Monday morning.
All right, Monday morning.
But we've already got the diversion paperwork, and Mr. King's office already given us the stipulations and everything. So the state's done everything. We're just trying to decide which option,
Okay.
if I could.
Yeah, you're still inside. Well, that's actually that's actually the 2 weeks in it. 21st is a Monday, so yeah, that you're okay by Monday.
Just maybe I'll set up a time with Marcia, Your Honor?
Yeah.
Yes, sir. Thank you.
All right. Any other matters then to discuss?
No, Your Honor.
Does the alleged victim of the offense been notified of the time, place, and purpose of this hearing?
Yes, they have, Your Honor. They're not present at this time.
All right. Thank you.
Thanks, sir.
Thank you, Your Honor.
So I want you to
All right, this is case number 24 CR 78, State of Ohio versus Alyssa Jenkins. And you're Alyssa Jenkins appearing there from the jail.
Yeah.
All right, this is a pretrial being conducted by Zoom. Ms. Jenkins' attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. Defendant charged with 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamines. This is a first pretrial, final pretrial set for October 16, and trial is set for November 12. I see the state provided discovery, and Mr. Kirk, I don't see yours yet, but yours will be due by the final pretrial. Do you anticipate any pretrial motions, Mr. Kirk?
Not at this time.
All right. Has there been a written plea offer provided to counsel?
Yes, Your Honor.
All right. Is your client aware of that, Mr. Kirk?
She is aware of it, yes.
Okay. All right. Are there any other matters need to be discussed on this case?
Not from the state.
No, Your Honor.
All right. Thank you. '86. State of Ohio versus Rebecca L. Deere. Are you Rebecca L. Deere appearing there from the jail?
Yes, I am.
All right. This is a pretrial, final pretrial. Defendant charged with aggravated possession of methamphetamine. Ms. Deere's attorney is Sarah Barger. She's appearing by Zoom from her office. Appearing from the prosecutor's office is Assistant Prosecutor King. Ms. Barger, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person hearing?
Yes, Your Honor.
And you're all right with that, Ms. Deere?
Yes, I am.
All right. Now, I have been provided with a plea of guilty form here, which indicates, Ms. Deere, that you're going to withdraw your not guilty plea and plead guilty to the charge. I'm going to hold this up to the camera and ask you if you recognize that first page. It has your case number, name, number, and says plea of guilty form.
Yes.
All right, on page 3, there's a sentence that reads, I enter this plea voluntarily, and right below that appears to be the signature Rebecca L. Deere. I'll hold that up to the camera and ask if that is your signature on that document.
Yes, sir.
And when did you sign this document, Ms. Deere?
Yesterday.
All right, and when you signed it, did you understand it's an agreement to plead guilty, which means there's not going to be a trial, and the next step would be a sentencing hearing?
Yes.
And did you have enough time to go over this and consider it before signing the agreement?
Yes, I spoke to her.
Do you feel that you were rushed or pressured in any way into doing this?
No, sir.
And you still want to go forward with this?
Yes.
And did you enter into this plea agreement voluntarily?
Yes.
Right now, the agreement says you're going to withdraw your not guilty plea, plead guilty to the charge, which is aggravated possession of methamphetamine under section 2925.11 of the Ohio Revised Code of 5th-degree felony. Further states you understand that the penalty for that could be 6 to 12 months, incarceration, defined at $2,500, and a possible license suspension from 6 months to 5 years. Do you understand that?
Yes.
All right. And are you facing any new felony charges other than the one you're serving time for in this case?
No, sir.
All right. You're not on probation, community control, or post-release control for a felony?
No.
Right now, under the law, if you're convicted of this offense, the adult parole authority could, upon release from prison, completion of your sentence, impose what's called post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms that the that the APA sets. And if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to a half of your prison term for one more violations. However, if the violation is a new felony, Then in addition, whatever sentence a judge in a new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. Do you understand that?
Yes.
Now, the law doesn't require a person convicted of this offense to be sentenced to prison. You can be sentenced to what's called community control or probation, and that means that instead of going to prison, you would be put under the supervision of a probation officer on the term set by the court for a period of up to 5 years. And if during that period of time it was determined that you had failed to comply, then the probation department would file a written notice out with the court. There would be a hearing, and if the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for the period of 6 to 12 months to fine you $2,500. Do you understand that?
Yes, I do.
All right. Now, the charge in this case alleges that on or about February 5, 2024 in Highland County, Ohio, you did knowingly possess, obtain, possess, or use a controlled substance, methamphetamine, Schedule 2's controlled substance, in violation of the statute. And that's the charge and with the penalties I've just described. Do you understand what it is the state said you did, when, where, and how they alleged you did it?
Yes.
And you understand the possible penalties for the offense?
Yes.
Now, under the law, or have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, and the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty today?
No.
Now, on page 2, there are some lines that are printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to the indictment. State and defense jointly recommend 9 months incarceration to be served concurrently to the term defendant is currently serving. Is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty?
No.
Now, under the law, the matter of sentence is not up to the parties. So even though there's an agreement as what the sentence ought to be, that's not binding on the court. And the court could determine that that's not the appropriate sentence to sentence you to something between 6 and 12 months, fine you, suspend your license if the court thought that was the appropriate sentence. Do you understand that?
Yes.
All right, now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Now, you have certain rights you must understand before I can accept your plea. First of all, you have a right to have an attorney, and I appointed Ms. Barger to represent you. That wasn't simply to work the case out, but to provide whatever defense might be available to you under the law that you wish to provide. So if you decide you don't want to do this, we'll continue to represent you in defending, including trial, if that's what you want. You understand that?
Yes.
Find out where she is. She's not involved in it. All right, now, you have the right to have a jury trial in this matter in which 12 people would be chosen from a group of citizens that are summoned from jury duty on trial date. Those people would all live in Highland County. After 12 of those Highland County residents were chosen, they would be the jury, they would hear the evidence, and then be told the law by the judge, and then they would decide based on that whether or not the state proved your guilt. Their decision would have to be unanimous, meaning all 12 of them would have to agree. If you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up the right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes.
Under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to be in court for you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, the court issues a court order. It's called a subpoena, and it forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination. which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
All right, now under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof isn't on you to prove you're not guilty. The burden's on the state to prove that you are guilty. And they must do that by proof beyond a reasonable doubt. And every element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
All right, now under the Constitution, you have, I think, privilege. Did I explain your privilege against self-incrimination?
Yes.
Okay, I thought I did, but I didn't check it. All right.
Yes.
Now, originally you entered a plea of not guilty, which denied the allegation in the indictment, denied you committed a crime, and exercised all the rights I've just described. If you change your plea today from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea will admit the allegation, admit that it's a crime, that you committed the crime, and that plea will waive and give up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney, no matter what your plea, but with that exception. Your plea of guilty would waive or give up your right to a jury or court trial. Waives or gives up your right to confront witnesses against you, cross-examine through your attorney. Waives or gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. Waives or gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. You're also subjected to being sentenced immediately by the court. And finally, you waive, give up your right to file an appeal on any alleged violations of your rights you think may have occurred up till this point in the case. Now, if you are sentenced to the maximum sentence or under the limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes, I do.
Are you a U.S. citizen, Ms. Deere?
Yes.
Do you have any questions about the charge, the possible penalties?
No, sir.
You understand?
Yes.
Have any questions about the plea of the plea agreement?
No.
You understand it?
Yes.
Any questions about your constitutional rights?
No.
You understand those?
Yes.
Any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No.
You understand it?
Yes.
Is there anything you need to speak to your attorney about before we go any further?
No.
You have any questions about anything we've done here today or talked about?
No.
Then is it your decision to go forward and plead guilty to the charge pursuant to the terms of the agreement?
Yes, it is.
Then as to the charge which alleges that on or about February 5, 2024 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, a 5th-degree felony, carrying a possible prison term between 6 to 12 months, a fine of $2,500, and a possible license suspension 6 months to 5 years. How do you plead?
I plead guilty.
All right. Court finds on this day in open court, defendants advised of all their constitutional rights, made no intelligent voluntary waiver of the same percentage of criminal rule 11. The pleas accepted order filed. Defendants found guilty of the offense charged in the indictment. Inasmuch as there is a prison term currently being served and a recommendation on sentencing, the court will not order a pre-sentence report, but will still proceed with sentencing. All right, Mr. King, on behalf of the state.
Only what is contained in the plea agreement, Your Honor.
Ms. Barger.
What is contained in the plea agreement, Your Honor?
You have anything you'd like to say, Ms. Deere?
No, I don't. Thank you.
What is the term you're serving now?
3 years mandatory.
3 years mandatory. Okay. All right. Well, it's the order and judgment of the court then that you be and are hereby sentenced to a term of 9 months in the Ohio State Reformatory for Women. Since this is what's called a TCAP case, the court orders that be served concurrently to your current term. It is possible upon completion of your sentence that you could be put under post-release control in this case for a period of up to 2 years, and if during that period of time the parole authority felt that you were not complying, they would they have the right, after making that decision, to return you to prison, to make you serve an additional period of up to half of your prison term for one or more violations, but if you commit a new felony, in addition, whatever sentence the judge in that new felony case can impose, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the new case. You're also ordered to pay the court cost, which judgment grant an execution order. If you don't pay that, then the clerk of courts could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, the court could permit you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded back to custody then. Thank you. All right, we need Justin. All right, are you Justin Stubbs there at the jail?
Yes.
All right, this is case number 24CR124, State of Ohio versus Justin Anthony Stubbs. Mr. Stubbs is appearing by video or by Zoom from the jail, and his attorney is Dennis Kirk. Appearing from his office, appearing on behalf of the state is Assistant Prosecutor King. Defendant's charged with receiving stolen property and aggravated possession of methamphetamine. This is the first pretrial, final pretrial set for the 16th of October, and the trial set for the 12th. I see that the state complied with discovery, and Mr. Kirk, have you filed yours yet? I don't see it if you have.
I have not yet, Your Honor.
All right, well, yours is due by the final pretrial. Are you anticipating filing any pretrial motions?
Not at this time.
All right, well, if you discover there are some that should be filed, they'll be due by the final pretrial. And have you received a written plea offer?
I have, and I have relayed that to my client.
All right. Are there any other matters then that need to be discussed in this case?
Not from the state.
No, Your Honor.
All right, then we'll see you back on the 16th, Mr. Stubbs. Thank you. All right, that's everybody in jail then?
That's correct.
All right. On 11, State of Ohio versus Amy M. Rickman. Ms. Rickman is appearing by video, by Zoom. Appearing on her behalf is her attorney from her office, Sarah Barger. Appearing on behalf of the state is Assistant Prosecutor King. The defendant is charged with aggravated trafficking of methamphetamine, a 4-3 felony, aggravated possession. This is a final pre-trial, and the trial is set for, I just lost it there, October 21. Now, I've been presented with a plea of guilty form. Ms. Rickman indicates you're going to withdraw your not guilty plea and plead guilty. Ms. Barger, do you and Ms. Rickman both agree to waive her presence in the courtroom and agree to proceed by Zoom?
Yes, Your Honor.
And you're all right with that, Ms. Rickman?
Yes, sir.
All right. If you should need to talk to your attorney at any time while we're in this hearing, just tell me, and I can put the two of you in a breakout room where you and her will be the only ones on the screen, and no one else will be able to see you or hear you, okay? Okay? You understand?
Okay.
All right.
Okay, sir.
All right. Now, Ms. Rickman, I've been handed this plea of guilty form, and I'm going to hold up the first page. Has the title of your case and with your name on it, and the case number, and says plea of guilty form. Do you recognize that form?
Yes, sir.
All right. On page 3, there is a sentence that reads, "Enter this plea voluntarily," and it appears to be right below that signature, Amy Rickman, with the date of 9/30/24. I'll hold that up to the camera, and is that your signature there?
Yes, Your Honor.
And you signed this, I take it, on the 30th of September?
Yes, sir.
Now, did you go over this and read it before you signed it?
Yes, Your Honor.
And did you have discussions with your attorney so that you would understand what it meant, what was in it?
Yes, sir.
Do you feel that you were rushed or pressured in any way into doing this?
No, sir.
Did you enter into this agreement voluntarily?
No, sir. Or yes, sir. Sorry.
All right. And it's been a couple of days since you signed it. Is this still what you want to do?
Yes, it is, Your Honor.
All right. The agreement says you're going to plead guilty to count 1, which is aggravated trafficking in methamphetamine under 2925.03A1, a 4th-degree felony, and that you understand that you could receive a prison term of between 6 and 18 months, a fine of $5,000, and license suspension from 6 months to 5 years if convicted. Do you understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation or community control or parole or post-release control for a felony?
No, sir.
Now, under the law, if you should be convicted of this offense and if you should be sent to prison, upon completion of that prison term, the law provides that you could be put under what's called post-release control supervision for a period of up to 2 years. And if during that period of time the probation department felt that you were not complying, they would file a written allegation of that with the court and give you a copy. There would be a hearing in which you would be entitled to have an attorney. The outcome of that hearing was that you'd failed to comply. Then at that time, the court could revoke your community control and then sentence you to prison for the 6 to 18 months, fine you $5,000, and suspend your license for between 6 months and 5 years. You understand all that?
Yes, Your Honor.
All right, now, and also if you should commit a new felony while on community control and receive a prison term for that, that sentence could be ordered to be served consecutively to the one in this case. Do you understand that?
Yes, sir.
All right, now the charge in this case in count 1 reads that on or about November 21, 2022 in Highland County, Ohio, you did knowingly sell or offer sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1 of the Ohio Revised Code. So that's the charge of aggravated trafficking with the penalties I've just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they allege that you just committed the offense?
Yes, Your Honor.
And have you discussed the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of the trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I am not.
Now, on count 2, on page 2, well, let me back up. Has anyone threatened you to make you plead guilty here today?
No, sir.
All right, now on page 2, there are 3.5 lines that are printed in bold and underlined that read as follows. Defendant will enter and plead guilty to count 1. State will dismiss count 2. State and defense jointly recommend community control, substance abuse treatment. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay bond money to the task force amount of $40. Is that your understanding of the agreement?
Yes, Your Honor.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, it's recommended the matter of sentence is up to the judge, not the parties, and so even though there's an agreement as to what the sentence ought to be, if you plead guilty, once I've heard all the information submitted, if I decide that's not the correct sentence under the law or the evidence, I could sentence you to a prison term of between 6 and 18 months, fine you $5,000, and suspend your license for 6 months to 5 years. You understand that?
Yes, Your Honor.
All right. Now, originally you entered a plea of not guilty, that plea exercised all the rights that you have under the law. Those rights include this. You have a right to have counsel, and I appointed Ms. Barber to represent you. It wasn't simply to work out the case, but to provide any defense that could be available under the law that you'd like to provide. So if you decide you don't want to do this, that you would rather defend against the case, She will continue to represent you, provide that defense if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this manner in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, and then they would be instructed on the law. That jury of 12 then would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you don't want a jury trial, but you don't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a quarter bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is the witness against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request for court issues a court order. It's called a subpoena. And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about it except in one situation. If there is a jury trial, you don't testify. The judge then does instruct the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent of this charge till proven guilty by the state of Ohio on every essential element by proof beyond reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty of this charge simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense. You may, but you're not required to, but whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charge by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, you originally entered that plea of not guilty, as I mentioned. That plea did not, or exercised all the rights I just explained. You changed your plea on count 1 to guilty. That's the opposite of the not guilty plea. And that guilty plea will admit the allegation in that count of the indictment, admit that it's a crime, that you committed that crime, and that plea will waive or give up all the rights I've just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and to cross-examine through your attorney, would waive or give up your right to use the power of the court to compel witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. Finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain limited circumstances, you could file an appeal. That appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir.
All right. Now, do you have any questions about the charge or the possible penalties?
No, sir.
You understand them?
Yes, I do, Your Honor.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, I do, Your Honor.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything you need to speak to your attorney about before we go any further?
No, Your Honor.
And is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the plea agreement that I've just gone over with you?
Yes, sir.
And as to the charge which alleges that on or about November 21, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell Methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1 of the Ohio Revised Code. The charge of trafficking, aggravated trafficking of methamphetamine, a fourth-degree felony, under 2925.03A1 of the Ohio Revised Code, with the penalties I've just described for you today. How do you plead?
Guilty.
All right. Court finds an open court on this day. The defendant made a knowing, intelligent, voluntary waiver of her rights pursuant to Criminal Rule 11 and entered a plea of guilty. The court finds that plea as knowing and voluntary, accepts the same. The court enters a finding of guilt based on that plea of count 1. Count 2 is dismissed. Matters referred to the probation department under the same bond. The report will include assessment for continuation of substance abuse and or mental health issues. Sentencing will be on November 6th at 9 a.m. That will be in person here in the courtroom. All right, is there anything further from the council?
No, Your Honor.
No, Your Honor.
All right, so probation department will get in touch with you and for a pre-sentence interview, then you'll need to be up here on the 6th of November. All right, thank you.
Thank you, Your Honor.
All right. Alexander, this is a pretrial being conducted by Zoom. Mr. Alexander's attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. Defendant's charged with 1 count of aggravated possession of methamphetamine, and that's a fifth-degree felony. This is the first pretrial. Final pretrial set for the 16th, trial set for the 12th of November. I believe that the state has provided a bill of particulars and discovery. And Ms. Hapner, your discovery will be due by your final pretrial. I don't see it here yet, but it's due by your final pretrial. Do you anticipate filing any pretrial motions, Ms. Hapner?
I do believe I will have a motion to file.
Okay. Well, it'll be due by the final pretrial.
Okay.
All right. Has there been a written plea offer provided?
There has been. I have not yet communicated that to my client.
Okay. All right. Well, Mr. Fillmore, you'll need to contact Ms. Hapner's office tomorrow and try to make an appointment to discuss that with her. Pardon me, or Mr. Alexander, I'm sorry.
Oh, okay.
All right.
Yes, sir.
I was looking at another file here. He's next, well, next in my stack anyway. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you. You can leave the room then to Mr. Alexander. Ms. Benson, the next case isn't until 2:15. That's Ms. Hapner's Jai Alexander or Kessinger, and then I believe we have Mr. Fillmore at 2:30. So is he going to?
No, I thought he was not on the docket for today.
Well, he is off the docket, and I don't know why. Do you know why?
I do. Already unmuted, so you're ready to go.
All right, are you Jai Kessinger?
Yes, sir, Your Honor.
All right, then that's the correct name to pronounce, the way to pronounce that first name?
Yes, it is, sir.
All right. This is case number 24CR109, State of Ohio versus Jai Kessinger. This is a pretrial being conducted by Zoom. Mr. Kessinger's attorney is Catherine Hapner, appearing from her office, and appearing on behalf of the state's Assistant Prosecutor King. This is set for a pretrial. The defendant is charged with aggravated possession of methamphetamine and possession of a fentanyl-related compound. And let's see, I'll look here for the final pretrial. Final pretrial is the 16th, and the trial is set for the 12th. Now, I have been presented actually with a plea of guilty form. And so, Ms. Hapner, are you and your client both in agreement to proceed with a guilty plea today without him being in the courtroom in person?
Yes, that's fine.
And you're all right with that, Mr. Kessinger?
Yes, sir, Your Honor.
All right. If at any time you need to talk to Ms. Hapner or ask her a question, since you're not seated in the courtroom with her, just tell me. I'll put the two of you into a breakout room. It'll be just the two of you on the screen, and no one else will be able to see you or hear you. Okay?
Yes, sir, Your Honor.
All right. Now, Mr. Kessinger, I have this form that says you're going to plead guilty, and it's a 3-page form. I'm going to hold up to the camera page 1. It has your name and the case number there and the plea of guilty to count 1. You recognize that page?
Yes, sir.
On page 3, there is a sentence about halfway down the page. It reads, "I enter this plea voluntarily." And immediately below that is a line for a signature of defendant. And is that, in fact, your signature there on that line?
That definitely is, Your Honor.
When did you sign this, Mr. Kessinger?
I believe it was last Thursday.
All right. Now, before you signed it, did your attorney and you go over it and she answer questions that you might have and explain it to you?
Yes, sir, she did.
And you understood that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step would be a sentencing hearing?
Yes, sir, Your Honor.
And did you have enough time to fully consider this matter before making this decision?
I did, Your Honor.
Did you feel rushed or pressured in any way at that time?
Absolutely not.
And since it's been a few days since you signed it, have you had any second thoughts, or is this what you want to go ahead and do?
This is what I want to go ahead and do, Your Honor.
And you're doing that voluntarily?
I sure am.
All right. Now, the indictment states in count 1, let me go back. First of all, page 1 does state that you're going to plead guilty to count 1, and that you understand that the maximum prison term for that could be 36 months. The minimum would be 9 if a prison term is imposed. There could be a fine of up to $10,000, and there could be a license suspension of 6 months to 5 years. And although there's a presumption under the statute that prison should be imposed for this type of third-degree felony, it is not mandatory. Do you understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony conviction?
Yes.
And where's that?
Clinton County.
All right, and what is the charge there?
Third degree possession of methamphetamine.
All right. And what's the status
Probation.
of that case?
Probation.
Okay, you're already on probation. When did you get put on probation?
I believe it was in June. This case was actually before that case.
Okay, all right. Well, the reason I ask about that is that in the event in the future you should be sentenced to prison in both counties, the sentences could be ordered to be served consecutively to one another, meaning in addition to. You understand that?
Yes, sir, I do.
Now, if you should ever be sentenced to prison on this offense, Mr. Kessinger, upon completion of that term, the Adult Parole Authority under the law has the right, if they decide to exercise it, it's optional, to put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised under the terms they set by a parole officer, and if during that period of time they determine that you're not compliant, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of the prison term for all violations. But if you're convicted of a new felony, then in addition, whatever sentence a judge in the new case could impose, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir, I do.
Now, under the law, I'm not required to sentence you to prison for this offense. I can put you under what's called community control or probation. And what
Yes.
that means is that instead of going to prison, as you know, you would be supervised by a probation officer under the term set by the court. The maximum period of supervision could be 5 years. During the period you're being supervised, if the probation department felt that you were not complying, they would file a written allegation of that with the court, give you a copy. There would be a hearing. You'd be entitled to have an attorney at the hearing. If the outcome of that hearing was that indeed the court found that you had failed to comply, then at that time the court could revoke your community control and then sentence you to the prison term between 9 and 36 months and fine you $10,000. And if you were revoked because you had committed a new felony offense while on community control in this case, and a prison term was imposed in that case, any term imposed in this case could be ordered to be served consecutively to the sentence in that case. Do you understand that?
Yes, sir, Your Honor.
Right now, the charge alleges, Mr. Kessinger, that on or about August 27, 2023 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance to wit methamphetamine, an amount that equals or exceeds bulk amount but is less than 5 times bulk amount. And so that's a violation of Section 2925.11. And that's a charge of aggravated possession of methamphetamine with the penalties I described earlier. Now, Mr. Kessinger, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir, I have.
Are you satisfied with her advice and confidence in this matter?
I am, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
Absolutely not. I've been clean for a year and almost 2 months.
Okay. Have any threats been made to get you to do that?
Absolutely not.
All right, now on page 2, there's a couple of sentences that read, they're underlined and printed in bold, that read, defendant shall enter a plea of guilty to count 1, state will dismiss count 2, state and defense jointly recommend community controlled substance abuse treatment. Is that your understanding of the agreement?
That is my understanding, Your Honor.
All right. And no one's promised you anything other than that to get you to plead guilty?
No, they have not.
Under the law, Mr. Kessinger, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement as to what the sentence ought to be, that's not binding on the judge. And so if you enter this plea of guilty, once all the information has been presented, if I determine that that's not the appropriate sentence, I could sentence you to prison for between 9 and 36 months. I could fine you $10,000, and I could revoke your driver's license for anywhere from 6 months to 5 years. You understand all that?
I do, Your Honor.
All right, now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
I did have a CDL license for almost 20 years. That is suspended.
Okay, all right. Now, you have certain constitutional rights you must understand before I can accept the plea of guilty. First, you have a right to counsel. Ms. Hapner was appointed to represent you. That appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So, if you decide you don't want to do this, that you want to defend against the charges, she'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir, Your Honor.
All right, now under the Constitution, you have a right to have a jury trial in this case in which 12 people would be selected from a group of citizens that live in Highland County who have been summoned for jury duty. After 12 of those individuals are selected, the evidence is presented, and then the judge instructs the jury on the law. And then that jury must decide, based upon the evidence of the law, whether the state proves your guilt. And it must do so by unanimous vote, meaning all 12 of them would have to agree. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
And under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
I do, Your Honor.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're now certain are going to come in voluntarily, at your request, court issues a court order called a subpoena, and that forces those people to come to court, be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses were forced to come into court to testify against you. You understand that?
I do, Your Honor.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it with one exception. There's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
I do, Your Honor.
Right now, under the law, you're presumed innocent of this offense until proven guilty by the state of Ohio on every essential element of the offense charged by proof beyond a reasonable doubt. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
I do, Your Honor.
All right, now originally you had a plea of not guilty. The guilty plea denied the allegation in the indictment, denied you committed any crime. And that plea gave up all the, exercised all the rights that I've just described for you. Now, if you change your plea from not guilty to count one, then that plea is the opposite of the plea of guilty. That plea admits the allegations in count one, admits that they're a crime, admits that you committed that crime. And that plea waives, gives up all of the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea, but without exception, your plea of guilty. Will waive, give up your right to a jury or court trial, to waive, give up your right to confront witnesses against you in open court, and to cross-examine them through your attorney. It'll waive, give up your right to use the power of the court to compel or force witnesses to be in court to testify for you the same as the state. It'll waive, give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. The waive gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to maximum sentence or under other limited circumstances, there could be an appeal filed. That would have to be filed within 30 days of your sentencing being filed. Do you understand all that?
I do, Your Honor.
And are you a U.S. citizen?
I sure am, Your Honor.
All right. Now, do you have any questions about the charge or the possible penalties?
I do not, Your Honor.
Do you have any questions about the plea agreement?
I do not. I've spoke it over with my attorney, and okay. I'm pretty clear on it.
All right. And again, you understand the recommendation on sentencing is not binding on the court.
I do, Your Honor.
Do you have any questions about the constitutional rights I've explained?
I do not.
Do you understand those?
I sure do, Your Honor.
Do you have any questions about the plea of guilty, what it means, and what the consequence of that will be if you enter that plea today?
No, Your Honor.
Do you understand?
I do understand.
Now, is there anything you would like to speak with your attorney about before we go any further?
No, I'm pretty clear on everything. We went over everything. I'm ready to get it over with.
All right.
I've been clean for a long time, you know, and I'm just ready to get all this off my back and ready to get on with life.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to count one pursuant to the terms of this plea agreement?
It is, Your Honor.
And as to the charge which alleges that on or about August 27, 2023 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance with methamphetamine, an amount that equals or exceeds bulk amount but is less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, a third-degree felony, carrying a possible penalty between 9 and 36 months in prison, a fine of $10,000, and a license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, court finds on this day in open court, defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. The plea is accepted and order filed. Defendants found guilty of count 1. Count 2 is dismissed. The court refers the matter for a pre-sentence report, and we will, under the same bond, and sentencing will be conducted in person in the courtroom on November 6, 2024 at 9 a.m. Need to call a probation, or, well, see Benson, Officer Benson there before you leave about an appointment for your pre-sentence report. And,
Yes, sir.
All right. Anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
All right, thank you.
Great, thank you.